All right, let's be on the record in case number 2020-CR724, captioned State of Kansas versus Isabel Benitez Miguel. Would the parties announce their appearances, please?
May it please the court, Karen Whitman for the state.
It please the court, Tom Fields on behalf of the defendant, Your Honor, and she is present with me via Zoom.
Let's hold on. That's my computer. All right, we are here set down today for a plea hearing. Ms. Miguel, to take up this plea, I'm going to have to ask you a lot of questions. So I need you to make sure that you answer out loud because my court reporter is taking everything down. If at any time I ask you a question you don't understand what I'm asking, tell me that, and you and I will talk about it until we're on the same page. If you want to talk to Mr. Fields before answering one of my questions, just let me know that. He can mute the microphone. You two can have a conversation in private and then come back when you're ready to continue, okay?
Yes, sir.
All right, to get this started, I need to have you sworn in. So if you'd raise your right hand, please.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
All right. Ms. Miguel, how far did you go in school?
Until 11th grade.
All right, you read and write English okay?
Yes.
As you sit here today, are you under the influence of any alcohol or drugs or prescription medicine that might cloud your mind, keep you from understanding what you're doing?
No, Your Honor.
All right, you feel like your mind's clear today?
Yes.
Do you know what you're charged with?
Yes.
You understand that you don't have to change your plea to these charges from one of not guilty to, are we doing guilty or no contest?
Guilty.
Guilty.
Okay. You don't have to change your plea from not guilty to guilty. If you wanted to maintain your not guilty plea, you would have an absolute right to a jury trial on these charges. Do you understand that?
Yes.
All right. If that trial happened, Mr. Fields would help you throughout that trial. The state would be required to put on enough evidence to prove you guilty beyond a reasonable doubt. You wouldn't have to prove anything yourself. Mr. Fields would have the opportunity to cross-examine and confront all of the state's witnesses. He could call any witnesses you wanted called. If they didn't want to come to court, he could use the subpoena power of the court to make them come. You would have a right to testify at that trial, but you'd also have a right not to testify. And if you decided not to testify, the state couldn't use that against you. In other words, they couldn't get up and argue, well, Ms. Miguel must be guilty because she didn't tell you her side. Do you understand all those rights that go along with a trial?
Yes, Your Honor.
All right. If we had that trial and you were found guilty at the end of that trial, you'd have the right to appeal that conviction to the appellate courts. If you didn't have the money to do that, a lawyer would be appointed to do it for you. Do you understand that as well?
Yes.
All right. Now, if we go forward with this plea, you're going to be giving up all of those rights. There's not going to be a trial of any kind in this case. You understand that?
Yes.
All right. I'm going to pull up here the plea petition that was sent to me. And let's see. Can you see that, Ms. Miguel?
Yes.
All right. Did you and Mr. Fields have an opportunity to go over this whole document?
Yes.
All right. I'm kind of scrolling through here so you can see.
For the record, she has a copy sitting in front of her too.
Fantastic. All right. Now I want to read to you specifically. Well, first I'll ask you, did you understand everything in the petition, or did Mr. Fields have the opportunity to explain anything you did not understand?
Yes, we discussed it all.
Okay. So I'm going to read to you here what's called the plea agreement. It says that you're going to plead guilty to count 1. That's DUI, third offense, and it is a felony. The state will dismiss all the other charges. On count 1, the parties are going to agree to recommend to the court that you get a 12-month jail sentence, and that I'm to suspend all but 90 days of that jail sentence. And you are eligible to do house arrest for that 90 days. You're going to need to attend a MAD impact panel, continue with your substance abuse treatment and any aftercare that's recommended by that treatment. You'll pay a fine of $1,750 for count one, which is the mandatory minimum fine, and a KBI fee of $400. You're not to drive unless you're properly licensed and insured, and having an ignition interlock on any vehicle that you operate during your term of what's entitled post-imprisonment supervision. Or as KDOR, that's the Department of Revenue directs. You cannot drink or take any illegal drugs. If you have any over-the-counter or prescription medicine, you must share that with your probation or your supervising officer so that they can make sure that those don't show up as some sort of prohibited substance. Ms. Miguel, I'll ask you, as I read you that agreement, is that the entire agreement as far as you understand?
Yes.
Has anybody promised you anything other than that agreement to get you to plead guilty today?
No, Your Honor.
Anybody placed any force or threats against you to make you plead guilty?
No.
All right. Now, I think this is a very important point. The maximum sentence in this case would be 12 months in jail. And there's no specific right for a defendant to have the court suspend part of that time or grant post-imprisonment supervision in lieu of jail time or house arrest, any of those things. Now, I'm going to listen closely to everybody's recommendations, but I'm not bound by any of those recommendations, and I can give you any sentence that the law allows me to give you. Do you understand that?
Yes, Your Honor.
And along with that, do you understand that the maximum for this case would be 12 months in jail? And Ms. Whitman, help me out. Is there a maximum fine in this case?
$2,500.
Yeah, it's $2,500.
$2,500. Okay. So the maximum sentence would be 12 months in jail and a fine of $2,500. Do you understand that?
Yes.
All right. Ms. Miguel, any questions about anything that you and I have gone over today?
No.
All right. And knowing all of this, is it your intent to go forward with this plea of guilty today?
Yes, Your Honor.
Mr. Fields, do you know any legal reason why your client should not plead guilty?
No, Your Honor.
All right. Then I will ask you, Ms. Miguel, as to count one, that's charging you with DUI as a third offense, which is an unclassified felony. How do you plead, guilty or not guilty?
Guilty.
All right. Now I'm going to ask the state to tell me what they believe the evidence would be. I want you to listen closely because when they're done, I'm going to ask you if that's what happened. Okay. Ms. Whitman.
Yes, Judge, on November 30th of 2019, officers were traveling in the area of South 14th Street and Pacific Avenue here in Kansas City, Kansas. When they observed a vehicle traveling at a high rate of speed, they detected it with their radar traveling 31 miles per hour in a 20-mile-per-hour zone. They stopped the vehicle and came in contact with the driver, who was identified as Isabel Benitez Miguel. They could detect a strong odor of alcohol coming from her. She had bloodshot, watering, glazed eyes. They were having trouble understanding her due to her speech was thick and slurred. They requested her to perform some field sobriety tests. Those tests indicated impairment. She basically resisted arrest. She was placed under arrest. A search warrant was obtained to draw her blood. Blood was obtained and sent to the KBI. The KBI analyzed it and determined her BAC was 0.18. Upon review of her driving record, it was determined she had at least 2 prior DUIs. One here in Wyandotte 17 TR 6211, in which she went diversion in December of 2017, and one in Overland Park Municipal Court March 15 of 2018. All these events occurred in Wyandotte County, Kansas.
All right. Ms. Miguel, you heard what the prosecutor had to say?
Yes.
Is that what happened?
Yes.
All right, thank you. I will find the defendant has freely, voluntarily, and intelligently entered into this plea. She understands the nature of the charges and the consequences of the plea. The state has provided a sufficient factual basis for a finding of guilt, and the defendant has acknowledged those facts. Therefore, I will in fact find that she is in fact guilty of count 1, DUI, third time, and a non-grid felony. I'm going to order that a pre-sentence investigation be conducted, and we're going to continue sentencing pending the receipt of that. I'm looking at, folks, about 6 weeks out. On Friday would be March 26th. I know Miss Whitman's busy in the mornings on Fridays. Could we do 1 o'clock in the afternoon on March 26th by Zoom for sentencing, Mr. Fields?
That date is fine with me, Your Honor.
And Miss Whitman?
That will work, Judge.
All right, that's when I'm going to set sentencing for, March 26th at 1 p.m. Let me ask this. Is the intent to have Miss Miguel start her house arrest, assuming the court follows the plea agreement, at sentencing? Does she need to be set up for it then? Is she going to get set up beforehand? Anything like that?
Judge, normally they get set up prior to sentencing because if you do order it, it's all ready to go. Because if you order it and she's not eligible, then that causes a problem.
Sure. So, Mr. Fields, you'll be able to get that set up before sentencing?
Yes, yeah, she's currently on ignition interlock, and she's maintaining her job and everything like that. So she indicated to me she shouldn't have a problem getting it set up. So who does she need to go through for house arrest? Just the
Lily Brown at pretrial services. I'm not sure what the phone number is there, but that's who she'll need to get with.
I'll get her number. Okay.
Fantastic. All right, folks, anything else for our record today?
No, Your Honor.
I know of nothing.
I suppose I should advise the defendant, as a convicted felon, it's prohibited for you to own or possess a firearm. Certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons, okay? Fantastic. All right, we'll see you all on March 26th at 1 p.m. We are